Hello and welcome back to On the Brink. This week we have one of my favorite people in the industry on the show, Gabriel Shapiro. He is a partner at the law firm Belcher, Smolin, and Van Loo, and you may have run into him on Twitter under the handle LexNode. So I've wanted to have Gabriel on the show for a really long time, actually. He has the Goldilocks perspective, in my opinion, in terms of being sufficiently optimistic about the industry and believing there's a kernel of something really interesting there, while still being pretty realistic about the darker underbelly. When you put it together, Gabriel tends to have a very balanced perspective. And really this conversation is about the key question that is often contemplated. Can the Lex Cryptographia be made compatible with the actual law in the West? Or is the blockchain industry doomed to exist completely outside the scope of the law? And of course, this spills over into questions of securities laws, which so far haven't really evolved much to suit the reality of digital assets. In this conversation, we go far beyond just the Howey test, and we consider some other precedents which elucidate the application of securities laws to the industry. And we talk about Hester Pierce's safe harbor proposal for tokens and Gabriel's engagement with her and critique of that proposal. And, of course, the infamous Hinman test for sufficient decentralization and Gabriel's proposed improvements to that test. Gabriel also gives his best pitch for a genuine security token which exists on-chain and isn't just a paper certificate, but a situation where an actual share is instantiated on-chain, and why that might be superior in some cases to the way that it works currently with most shares of stock held at the DTCC. And just as a last note, if you've enjoyed this conversation, which I think you will, I really recommend Gabriel's 4-part series of Medium posts entitled Size Does Matter, a philosophy of securities laws for tokenized networks, where he effectively tries to sketch out a world where securities laws and crypto asset issuance can be made compatible, which I think is super underrated and really one of the best things written on the topic. So without further ado, let's dive into the show.
Brought down by bad mortgage investments, Lehman, which has 25,000 employees, will be liquidated.
The federal government loans American International Group, AIG, $85 billion.
This is a different kind of market, and the Fed is asleep.
The federal government is stepping in to stabilize Fannie Mae and Freddie Mac, the two mortgage giants that have been threatened by the housing crisis.
The Bank of England has pumped £75 billion more into Britain's ailing economy with a new round of quantitative easing.
You print a couple $1 trillion, and all of a sudden, people start to worry. So out of this worry, we have something called the Bitcoin.
Gabriel is a partner at BSV Law, no relation to the coin. Gabriel, I've obviously been a fan and a follower of yours for a really long time. I think you occupy a very unique intellectual niche in the crypto industry, especially as it pertains to the intersection of law and smart contracts and blockchain, etc. I know there's a lot of crypto lawyers, but you are one of my favorites.
I appreciate it.
Number one, I don't want to play favorites, but you're definitely up there. Thanks so much for coming on. I think we're going to have an awesome conversation.
Indeed. Happy to be here. Thanks for having me.
So you've been very liberal with your opinions lately, which is great because, us non-lawyers, we need kind of intermediaries, and we rely on people like you to interpret this stuff for us. I think I found that a lot of crypto lawyers tend to get captured by the industry in some respects, but you seem to have retained a fiercely independent streak, and you seem beholden to no one and no project, which is awesome. So maybe to start, why don't you briefly tell us about your firm and what you do there, and then we'll dive into crypto law.
Sure. So I'm at a boutique firm called Belcher, Smolin, Van Loo, which unfortunately gets abbreviated to BSV, although we don't have anything to do with Bitcoin Satoshi Vision. And essentially we're all traditional corporate lawyers who were in the big Wall Street firms for a significant chunk of our respective careers. And eventually became slightly too weird or interesting to stay in that environment, and decided to branch out on our own and try to do something a little bit different. So we do fairly normal things like M&A transactions and venture capital financings. There's another corporate partner, Aaron Belcher, and the two other founding partners are Jonathan Van Loo, who's a tax lawyer, and Stuart Smolin, who's an IP lawyer. So we kind of cover the gamut for M&A deals and venture capital deals. But then mainly Jonathan Van Loo and myself do a lot of work for blockchain projects, and it's mostly on the startup side. So people, DeFi entrepreneurs is a big category right now. But anyone who has any kind of interesting project and is looking for legal advice or just help getting a transaction done, like a commercial agreement or something like that, these are all things that we help with.
And prior to crypto, you did corporate M&A, correct?
Yeah, I did almost exclusively buy-side tech M&A in Silicon Valley for the really big companies like Facebook and Oracle and eBay and so on. And so that was about 8 years of my life doing close to exclusively that.
And I mean, you seem to be more on the kind of Ethereum side. Was it the Ethereum crowd sale that piqued your interest, or when did you start to focus on the industry?
Sadly, I missed the crowd sale, or I would be probably even more independent because I wouldn't have any need to keep getting paid. But it was Ethereum because I was interested from the Facebook WhatsApp deal, which I was sort of like the senior associate on the Facebook side. I got very interested in end-to-end encryption, and I just started going down that rabbit hole, and eventually it led me to cryptocurrency. For whatever reason, it was Ethereum that caught my imagination, probably because it uses the word smart contract. And ironically, the first event I ever attended was Nick Szabo giving a talk at an Ethereum meetup, something that's unthinkable today. But of course, he has a JD, and he wrote a lot of articles about the relationship between technology and law. So that was an ideal entry point for me as a lawyer who, at the time at least, wasn't particularly technical. And it just sort of spiraled out from there.
Yeah, I guess Nick Szabo's had a bit of a falling out with the Ethereum crowd. From I think they might have named a unit of currency after him.
Yes.
But he seems to have kind of soured on the Ethereum project specifically, although I don't know. I don't want to put words in his mouth, but obviously he coined the notion of a smart contract, so he still presumably likes the concept.
Right.
What was his talk about? Just out of curiosity.
It was a big part of it was about the DAO, which at the time had not yet imploded, and just sort of talking about the smart contract notion, talking about the history of money, the typical Nick Szabo stuff, that we're still familiar with today. But he did seem very fascinated by the DAO at the time. And I suspect that's also likely the source of the beginnings of his disenchantment, was when there was a hard fork to reverse the effects of the DAO hack, because he's big into governance minimization and so forth.
Yeah, the DAO was quite central in my own revival of interest in the crypto industry. I kind of stopped paying attention to it as much after 2014, and then I saw the DAO in the news, and I thought, there's some new stuff going on here. And then, of course, I like many people, was a little bit disillusioned with the irregular state change.
Yeah, for sure.
Classic euphemisms, kind of like central bankers love to use euphemisms. Kind of the same situation there. So let's dive into the one first really big question, which I think you've great opinions on. So, people have different opinions on what quote unquote crypto or public blockchains are actually for. What would you say the kind of central conceit of the industry is?
I think the central conceit is asset and transactional sovereignty. And I think the word sovereignty in there is a good one because as a lawyer, what I focus on is the fact that individuals are not actually supposed to be sovereigns. They are supposed to be subject to the law of the jurisdiction where they reside, where they're citizens or where they're physically located. And so to me, right within that phrase, when people talk about, hey, the merit of Bitcoin is that it's unconfiscatable, even if that's sort of an exaggeration, or the merit of DeFi is that you can be your own bank. What I focus on is that there is an inherent tension of this with normal concepts of law, and that this makes it inevitable that the technology is in part, yes, if it's functioning well, it helps you evade law or lower the likelihood of law enforcement or be your own law, whatever that means. And this is a tension.
Yeah, it might seem curious to crypto folks to hear the bear case for transactional sovereignty, but that's actually, if you zoom out a little bit, asset or transactional sovereignty is not the norm practically anywhere. I mean, we have these systems which are profoundly intertwined with property rights, which ultimately traces to the state and the legal apparatus. And crypto and Bitcoin and so on is actually doing something well outside of the ordinary. I guess that's kind of the whole point. So in that context, would you say, what the builders in the crypto industry are trying to achieve is sort of fundamentally hostile to the law? I guess this is really the big debate. Is it something that fundamentally tries to override or exist outside that kind of legal space?
Well, I think that'd probably be too sweeping a statement because there probably are many uses of the technology that are legal. I would sort of compare it to Tor, right? The Tor protocol obviously, notoriously allows things like dark markets to exist on which illegal drugs can be sold. You can supposedly hire hitmen, and there are supposedly red rooms where people get like tortured and people pay to watch. I don't personally know how many of these things are myth versus reality, but even if they are myth, the reason why the myths are popular is because people really could do things like that with Tor and have a greater likelihood of getting away with it. And so cryptos, but on the other hand, Tor could also be used for amazingly beneficial and important things. Like it could enable dissident groups in oppressive regimes to communicate with one another or to communicate with the outside world and hopefully not be detected and punished by their government. It could allow like a North Korean citizen, right, to communicate securely with people outside of North Korea. So yes, there are both pros and cons that arise from this type of technology, but the very same thing that is good because it lets you escape the bad laws of North Korea can also be bad because it lets you escape the good laws, not that they're all good, but many of them are good, of the United States. And so there is an inseparable tension.
So I guess to kind of synthesize that, it's really contextually dependent. I guess crypto asserts its own kind of proto-law or very rough outlines of the law in terms of what is permissible under the protocol. And in some cases, the kind of property rights or the system of property rights that's produced might be superior to some local jurisdiction where, there's very little protection for property rights. But in mature settings, it might be inferior, or it might be kind of less suitable than just the standard model.
Yeah, that's right. I would agree with that.
Okay, so there's definitely a clash between quote-unquote crypto law and law. Maybe there's some synergy possibility, some pockets of synergy. What do you think the promising veins there are?
Right. So I definitely think there are massive potential synergies. I used to be a lot more optimistic about them when I first got into the space, and I've become less optimistic just based on the way that the regulators have ended up actually dealing with it, and just basically based on happenstance of the way things have turned out. But a great example of potential synergies is tokenized securities, right? We have in traditional corporate law, right? There's certificated securities, and in theory, a token could be a lot like a stock certificate, and it could trade peer to peer a lot better than a paper certificate can. So we have currently in our public equity markets a very, very elaborate and I would argue inefficient system of intermediaries that really just grew up around the fact that paper certificates are difficult to trade at scale. And in my opinion, blockchain could be used to pretty much dismantle most of that apparatus and reduce reliance on intermediaries, increase privacy, make the relationship between public companies and their shareholders a lot more direct, because right now a lot of public companies don't even know who their shareholders are or have a way of communicating with them. And so that would be a great thing. Now, nothing like that is going to happen anytime soon, unfortunately, because within the SEC and within the broker-dealer industry, there's a big movement not to let that happen and instead to pursue a policy of mandatory intermediation with respect to representations of securities. And that if you talk to the SEC about these things, or at least if you talk to the Division of Trading and Markets, which is the one that is sort of most involved in this sort of thing, they will basically tell you that Ethereum is not the right kind of thing for securities to be on, right? Because it's not a registered securities exchange, nor could it ever be a registered securities exchange, and it's not what we call an ATS, alternative trading system. So this makes this very problematic. Now, listeners will probably be saying, wait a second, I heard about INX. Isn't that a tokenized security? And I heard about this other one. Well, I would not define those as tokenized securities, because the way that they got regulatory approval is they have a registered transfer agent sitting in between the blockchain and the stockholders in the company, and the legal position is that the ledger maintained by that transfer agent, the off-chain ledger, is the definitive legal ledger. So what that really means is that the token, since the blockchain itself is not the definitive ledger, and also the tokens are not something like stock certificates, really the token is just sort of like a legally meaningless souvenir that you own that security, and it's all still intermediated. So in that sense, the blockchain is kind of pointless for that. No offense to those involved, because I know some of them and I like some of them, but I'm sure they would have liked to have done something that's more true to blockchain as well, but they're just not able to at this point.
Right. Yeah. So TokenSoft is the transfer agent, and the tokens themselves, which circulate on Ethereum, are effectively paper claims. But the real dossier of who owns what is actually maintained by TokenSoft, with Ethereum just being kind of a representation of that.
That's right.
Yeah, so you're referring to kind of tokenized securities as in equities whose shares could be the ownership, which could be represented on-chain, as opposed to tokens, which happen to be securities, although I guess eventually those could converge.
That's right. Yeah, tokenized security is like a traditional security that's been put in token form, as a representation. A security token, in the nomenclature I use, is a token that happens to be a security.
So the benefits of, because I feel like people in crypto, and I noticed this after in the debate around INX, people in the industry don't really know much about how regular shares are actually apportioned and the intermediation and the multiple levels. And frankly, I didn't know much about it until I looked into it too. But effectively with stock certificates, mostly they're held by a single entity, if I'm not getting this wrong, the DTCC, and which is kind of jointly owned by exchanges and broker dealers and banks. But the actual end users don't really actually own shares of stock. Is that kind of like the appropriate? They don't.
Yeah,
at
that's
least
right.
Hold shares of
That's
stock.
right. Basically, DTCC owns what's called a jumbo certificate, which is actually often a paper certificate issued by the corporation that represents like close to all of the shares of common stock of that corporation. And then basically what happens is claims on that certificate trickle down to banks and broker dealers and other intermediaries, and then ultimately to customers. In commercial law, this is reflected as there are kind of like three ways of holding a security. One is certificated, so DTCC holds a certificated security, and that's the best way because you can trade it without the permission of the issuer, right? As long as you're not violating a contract or something in doing so, just by like signing it. I hereby give this stock certificate to Nick Carter. You can hand it to them. So that's the best way, but it occurs very rarely, right? Because the more dominant ways are book entry or what's called a security entitlement, which is really a claim you have against a broker for that broker to get to assert its claim against the stock certificate held by DTCC. So yes, it is heavily intermediated, and it does lead to practical problems because, for example, if a public company is getting acquired and all stockholders have what's called dissenters' rights in connection with that acquisition, then you want to really know who holds the stock so that you can go and ask them whether they dissent or whether they approve. And it's actually very hard to do that because not only is there this intermediation, but there's also privacy within this intermediation. And so, for example, a lot of holders are what are called OBOs, objecting beneficial owners, which means they do not want the company to know that they own their stock. This opens up other problems, like it enables activist investors to more secretly acquire stakes in companies that they're going to effectively sort of try to blackmail into changing their boards of directors and stuff like that. So it's very complicated, and each approach has pros and cons, but personally I think it would be better to get rid of these intermediaries with blockchain and have a more direct relationship between the companies and their stockholders.
And this whole system is kind of an emergent artifact of the fact that shares used to physically be pieces of paper, and that just wasn't efficient. And at some point in the maybe 60s, 70s, everyone realized it was just easier and more convenient to keep the shares in a warehouse and trade claims on those paper certificates. And that's why it looks the way it does today. Not that it's necessarily the best system, but that was just sort of a natural outcome of the old technology we had.
That's right.
One thing that I encountered when I was researching this recently is the fact that in shareholder vote situations, you occasionally get double or triple voting because the corporations, as you say, they have a hard time accounting, and the brokers, and due to lending and things like that, they have a hard time accounting for who actually owns the shares and who has those voting rights that they can exercise. So in some situations, you get votes which exceed 100%, or shares which are voted on twice, which I thought was pretty entertaining. And I think, the potential of a public blockchain to improve on that is pretty obvious.
For sure.
Are there other kind of transactions where you think tokenizing the shares on chain would be far superior to the way things work today?
Well, once you have that type of real tokenization, I think there's a whole lot more you can do from there, right? Like you can imagine getting now into the space of privately held companies, whereas we were just talking about publicly held companies. Venture capital backed companies have amazingly complex capitalization structures, right? There's there's common stock sitting at the bottom. Sometimes there's even two classes of common stock with different numbers of votes per shares. And then on top of that, you might have like a Series C, which has a liquidation preference. It may be participating or non-participating with the common in an exit event. Then you'll have your Series A, Series B, Series C. And for each of those, they all can have different parameters. They have different liquidation preferences. They may make different choices about whether there's a cumulative dividend, whether the shares only get paid their liquidation preference in an exit event, or also get paid their common, a part of what the common stock would get after the liquidation preference is paid off. There also can be different choices about whether or not they are convertible into common stock and under what conditions that conversion can occur. So this is how we made our money as M&A lawyers, right? Because in the exit event, there had to be this extremely complicated drafting that sort of embodied all these formulas, and you had to make sure it worked the right way and that everyone got paid the amount that they're legally supposed to get in that specific merger. So a lot of this could be automated, right, through smart contracts and so on. You just sort of set it up right at the beginning, and then everyone trusts the smart contract to apportion the amounts the same way. So I had a startup called Zero Law, and we had a great genius Solidity developer named Ben Hauser, who actually wrote the code for this, although we couldn't convince anyone to really want to use it. So that code exists if you're ever interested in poking around what we had done there. And I do think it could be enormously beneficial, but because of the regulatory hurdles and just fear of the unknown, I don't expect people to start using it anytime soon.
I was going to say this is hitting a little too close to home, and it sounds like the kind of things that I worry about every single day. And it's the reason we spend so much money on lawyers. But yeah, I think the point is a good one. The relationships between investor classes and shareholders and directors in practice tend to be encoded at, I guess, really fancy Excel spreadsheets that law firms administer. And it may well be far more efficient to encode all these things in a transparent manner, such that you can reason about them more simply.
That's right.
That's certainly persuasive to me. What are the hurdles there, the barriers? Would you say they're primarily regulatory or tech or convincing people to adopt a system like that?
Yeah, the challenge with all these things, I think, is any of the things that we're talking about, they sort of all become useful together, and it's difficult to incrementally work toward them, right? Like the tokenization for private companies would be very appealing if tokenization also was a viable path for public companies, but because of the regulation, that's not going to happen anytime soon. So that makes it less attractive even for private companies, and so similarly, right, if the tokens were certificates, then you could do really neat things with them, like you could pledge them as collateral for a loan, and there's a concept of perfection of a security interest by possession, which applies to certificated securities but not uncertificated ones. So that'd be like a very useful thing, right? But unfortunately, this policy of not allowing certificates on chain, but only allowing sort of souvenirs of ownership on chain, prevents that. So it's one of those things that where the uses all have to be together for it really to be attractive. And right now, too many of them have too many frictions for that effect to occur.
So let's talk about crypto law as it's practiced. You've been actually fairly critical of the kind of domain of crypto law. I mean, for a number of reasons, but what would you say, the current attitude of crypto lawyers is vis-a-vis regulation and in terms of token issuances? What's kind of the prevailing attitude in the industry?
Right. Well, I think first of all, it's a tough job, and I think everyone has pretty good intentions, right? I don't know of any crypto lawyers who are like Saul Goodman, where they're giving the pitch, hey, you don't need a criminal lawyer, you need a criminal lawyer. But that being said, it's tough because there's just not a lot of guidance or precedent out there. The regulation has evolved much more slowly than certainly I ever expected, I think, than most people expected. And so there arises a situation where people have sort of geared their careers around providing advice in this industry, but in my opinion, don't have great advice to give. And so it kind of turns into a little bit of a window dressing exercise, I guess is the best way I can put it. In an ideal case, lawyers would not really be doing window dressing. In my opinion, they'd be really saying, here's the law, you comply with it or don't, right? But this is what it is. If they're a litigator, of course, it's different. I'm not a litigator. I'm a transactional attorney. Once someone has already done something wrong and you're talking to them after the fact, then yeah, your job is to defend them by any means, by hook or crook, I would even say, right? Because everyone deserves a really zealous defense attorney in a litigation context. But most of these lawyers are not litigators. They are actually talking to people before they've done anything. And it just becomes a very difficult exercise. And I do think it's like, in order to be able to add value, a lot of the value I think you end up adding is just sort of security by obscurity and more making enforcement actions less likely, but not necessarily increasing the level of legal compliance or achieving a strong level of legal compliance.
To what extent would you say this situation is a function of kind of a leadership vacuum from the securities regulators?
A very high extent, right? Because they've just been very reluctant to say anything they like, other than a couple of no action letters that were so incredibly conservative that some have even argued it was crazy to ask for a no action letter in those circumstances. And so if they were more proactive, right, for example, they came out with this idea, well, if it's sufficiently decentralized, then it's not a security anymore. Okay, well, no one knows what that means. They didn't define it. And they listed like various like circumstantial factors, but didn't weight them in any way or say which ones are necessary or sufficient. They didn't provide a safe harbor process of any kind, which would be sort of like an especially conservative version that you could follow to know for sure that they won't pursue you. And so, you know a lot of what they don't like, but you don't know exactly why they didn't like it. And you don't know of the things that they haven't gone after, whether it's because they've made some determination that they're compliant or they just decided for practical reasons that it wasn't a good target for them to pursue. And so it's extremely difficult, to give good advice with any level of real confidence.
Yeah, that's kind of my mental model of the SEC. Actually, the SEC capital case kind of made me think of this, that like any other kind of organism, the SEC has limited resources and they want to maximize the impact of their available resources. And because there's kind of a virtually unlimited quantity of enforcement actions they could sort of pursue, or opinions they could express, they have to be actually quite judicious in terms of their resources. And so then you have this strange situation where the lack of an enforcement action doesn't mean that something has been baptized by the SEC per se. It could just be the case that they are resource strapped, or for really any reason, they're not pursuing it. But that doesn't mean that it has their blessing.
That's right. And I think there is way too much tea leaf reading in the industry where people just kind of assume that a lot of things are legally compliant because regulators didn't go after them. And it's just not the case, right? I mean, it makes it very difficult for a lawyer to do their job, right? Because instead of talking about actual court opinions and precedents and comparing that to the facts at hand, people want to say, oh, well, it's a lot like MakerDAO. So, and isn't MakerDAO fine? No one has gone after it yet. So they basically want you to treat it like MakerDAO as if it's a legal precedent, but it's not a legal precedent. And so it just gets very frustrating very quickly.
And I guess the other thing is that the SEC takes time to get these kind of enforcement actions lined up, and so there could be a significant latency. I think the statute of limitations in some cases is 5 years in a securities context.
That's
so
right.
There could be a very significant latency between the existence of an infraction and an action, and people interpret that latency as approval, but that all it means really is that there's a delay, and the chickens haven't come home to roost yet.
That's right. And the other thing is that, my impression at least is that the regulators don't like to get in the way of private litigants. So you look at a situation like the XRP situation where a class action has been brought. My guess, again, it's a pure guess. I don't want people to think I have some inside knowledge or something like that. And I don't think anyone barely has inside knowledge, but, unless they actually work for the SEC, because they're pretty discreet. They're pretty good about it. But with the XRP situation, currently there's a private litigation. So why, as a regulator, would you ever want to get in the middle of the actual investors who suffered losses in their case? You want to let that play out. If the private litigants win, then just like in the Theranos case, where the SEC came in afterwards and imposed a fine, then they could always impose a fine afterwards, right? And it's even easier for them to do so because the case has already been proved. So there absolutely are tactics involved in this, and you can't make too many inferences about the legality of a project based on what the SEC is doing.
So they prefer to let the quote unquote free markets of civil suits play out if one is present before diving in.
I believe so. Yeah.
That's interesting because it can just take so long to settle a civil suit. And in the case of Ripple, the founders made presumably billions of dollars in that period. I don't know if it's the most elegant solution exactly.
Yeah, I agree. But part of, that's why we have the right to bring private actions under the securities laws, is because the SEC is resource limited, and, in some sense, the investors might be the best position to pursue their own claims, right? And so it is an intended part of the system, but yeah, it can lead to some odd effects.
Well, as an advocate of free markets over, excessive state involvement, I would generally support something like that. I think maybe the disanalogy with the traditional securities industry, which is kind of fairly jurisdiction specific, you have Americans suing American companies for securities fraud and so on. In the crypto industry, you have these global token holder bases. They tend to be quite fragmented, very retail driven, and they, in some cases, the investors don't really want to KYC themselves for tax reasons, among other things, and they, many of them will be privacy focused. So the consequence of all that seems to be that the private litigants, I guess, or the private plaintiffs, tend to be pretty ineffectual from what I've seen so far. Would you kind of agree with that characterization?
Yeah, I think that's right. There are challenges to it. You're right; it is global, and especially if you're fighting against someone who really raised a lot of money through their token sale, like Ripple. They're able to go out and hire the best and the brightest, right? Like Ripple hired Mary Jo White, who's the former, chairwoman of the SEC, for their defense. So it's a big investment for a class action attorney to pursue this type of case. It may take them years. It may take a lot of resources, and there probably are not that many who are willing to make that investment. XRP is probably a big enough fish that the settlement could be, sufficiently large to embrace it. And the cases the SEC has gone after, a lot of them are also big ones, right? Like Kick, like Telegram, that raised, really fortunes. So a lot of the result is that a lot of the smaller fry, end up getting away with it or going under the radar, whatever way you want to put it. And that might not be the best incentive people want to set up. Oh, as long as it's like pretty small in cloak and dagger, then you're much less likely to get hit.
It's interesting. I've seen it both ways. One of the most telling juxtapositions for me was the EOS, the resolution of the Block 1 EOS case with the SEC versus the Nebulous case, or Sia, which I think they might have actually settled on the same day.
Yeah.
As you recall, EOS raised reportedly around $4 billion. They settled for, was it $20 million with the SEC? And Nebulous, which was run kind of out of an MIT dorm room, the token sale was for a couple $100,000.
Yes,
and
that was a bad. I hated to see that one. I mean, because they got hit so hard for this tiny thing that was even before the Dow report. Which supposedly they were going to punish people before the Dow report. I don't know what happened there. I don't know. There must have been something that brought it to the SEC's attention and it made them want to go after it, despite being so small and so on. But I consider that very unfortunate, right? Yeah.
Yeah. We had David Vorick on the podcast of Sia. He talked about it. I believe they had actually gone proactively to the SEC because, the instrument that they raised was equity-like. It was effectively, a share of cash flows in the putative network. So the Sia funds, that is. So clearly it did, have some sort of securities considerations. And I think they took notice of that and eventually recognized that once they became more familiar with the law. But the penalty was quite significant, and I think there was a fine as well. Luckily they were big enough that they could kind of stomach that loss when they finally settled. But I thought that juxtaposition was a pretty telling reminder of, might makes right in some cases in this industry.
That's right. And, again, I don't want to be a jerk, right? But the general counsel of Block 1, who is most likely involved in structuring the token sale, he still gets to testify before Congress and stuff on policy issues. So yes, absolutely. I don't think the regulators are doing a great job in listening to the right people, rewarding the right people, creating the right incentives. I think they're falling down badly, and I don't think they understand the way the industry works very well.
So this is probably a natural place to talk about Hester Pierce's safe harbor proposal. You actually engaged with her on Twitter about it, and I think she responded. To her credit, she is very active on Twitter, and makes kind of humorous tweets sometimes. But so tell us a little bit about her proposal. And
right.
You actually wrote a response to it, which she engaged with as well.
That's right. Yeah, and she actually was. She went even further than that. She was charitable enough to have an hour-long lunch with me in San Francisco and discuss things. So I really appreciated that, and I think highly of Hester Pierce. So let's just situate the context here, right? Because Hester Pierce is a commissioner, right? She's one of, I think there are 4, right? And then the chairman is Jay Clayton, who won't be chairman much longer, most likely. And so really what they do, the commissioners, they're not super involved in the day-to-day as far as I know, but they vote on a lot of things. They vote on which enforcement actions to take. They vote on whether to approve rule changes and things of this nature. So essentially they're political appointees, right? And Pierce was also SEC staff for a period of time. So I think she does a great job as a commissioner in advocating for policy changes and so on. And I think what she responded to is this: okay, we've put out this sufficient decentralization idea, but what about the period before something is sufficiently decentralized? It's going to be a security during that period. We've done a very poor job of creating a path that would allow securities to legally be on Ethereum, for example, because the Trading and Markets Division says that Ethereum's not the right kind of place for securities to be. So what do we do? There's this catch-22, and from that point of view, her idea is a very good one, right? Which is to give this 3-year period to kind of become sufficiently decentralized. The fraud rules under the securities laws would still apply, but the registration requirements and the other things that people consider very onerous to comply with wouldn't apply, right? And then at the end of the 3 years, you'd look and you'd say, okay, is it? And this is where my main quibble lies. You'd say, has this network reached network maturity, which is defined as either being not controlled by anyone in particular, which is sort of the sufficient decentralization idea, or being quote unquote functional. Now, it's that functional one that I don't think is consistent with current securities laws. I don't think just because something has a function that it's not a security. It really just depends on why people are most likely to buy it and who is responsible for continued upside after the point where they buy it. But it's a serious proposal, and look, I think it would be much better than the status quo we have today. Myself, I would prefer, again, just because I think this is more consistent with current securities laws in the US, I would prefer if they just stuck more to this sufficient decentralization test, but fleshed it out a lot better, and then created a meaningful way that a token can be a security for some period of time, but still be usable within the context that it's supposed to be used. And I don't know which way it's going to go, but I think we need one of these two types of ideas, because right now it's just people are basically being forced to take a very high risk of breaking the law.
So a lot to dig in there, but on the notion of the functionality of the token, something that comes to mind to me is one of my favorite examples, which is if you own something like 100 shares of Ford stock, you could actually get a shareholder's discount on a new truck.
Right, exactly.
You used to have to actually fax in your copies of your stock certificates or something crazy like that. But
right.
It was instrumentalizable into effectively an employee discount, which is kind of a little known fact. But that doesn't mean that the Ford stock wasn't itself a security. Obviously,
Exactly.
The primary reason people bought it was to, speculate on the performance of Ford, the company, and receive dividends and so on. So I guess your point is the element, some functional element doesn't obviate the security-ness of the asset, basically.
That's right. Nick, in another life, you would have made a very good securities law attorney.
Yeah, well, maybe there's hope for me yet. Are there any precedents that you draw upon when you're considering this disjunction between functional tokens and investments? Are there any kind of interesting precedents that we should be aware of beyond just
the main one is sort of a dyad, right? And it's helpful because it's both about the exact same things, which is buying shares of something in order to get like a living space, like an apartment or a condo. So the source of the idea that if you buy something for consumer reasons, it's not a security, is a case called, I believe it's SEC versus Foreman. I always just call it the Foreman case. But and in that case, people were buying something called stock, shares of something called stock, in basically like a condominium association. And I guess some of them must have been unhappy with the way everything went. I guess the value of their condos must have gone down. And so they brought a lawsuit for rescission against the sellers to say, hey, this actually was a securities transaction. I bought stock. So, I want a securities law rescission and I get all my money back, right? The claim was rejected. And the reason why it was rejected, even though it was called stock and stock is an enumerated security under the 33 Act, the judge said, no, you have to look at the substance of the situation. The reason why people were buying shares of stock here was not to invest in something, but it was because buying stock bought you a condo. Right, there was a specific ratio of like shares to condo, and each person only bought like one of the condos, and the shares were non-transferable. And in the event that you sold your condo, you could sell them, but then like the upside was capped to the condo sales price, and all this kind of stuff. And so you just look at the facts. People weren't buying an investment; they were buying a house, right? And that is the origin. Now there's a very superficially a very, very similar case called Teague versus Baker, which was against the infamous Jim Baker televangelist from the 80s, who eventually went to prison for fraud. And I think it might have even been in connection with this same exact case. But they sold shares in basically like timeshares in their religious resort, right? And you would think that that's very similar, right? Because the shares entitled you to use a room there for some number of days each year, right? Sounds very similar. But the judge said, no, this is very different, right? Because you didn't have to buy the shares, right, to get the room. Other people could also get the room, and the more popular it became with people who didn't hold the shares, the more the shares would be worth, because you could give your room to someone else, right? And so there were all these differences, and the main one people tend to focus on in that case, and I think it's a bit of a red herring, is that the word investment was used a couple times in some of the literature, but that's not the only reason it was held to be a security, right? It was structurally a security. And so comparing those two to each other is very useful for assessing whether people are likely to be seen as mainly having a consumer type orientation versus an investment type orientation. Unfortunately, condos are very, very different from tokens, and there's not a better case that's somehow closer to tokens, but so it goes.
This seems incredibly salient and a very helpful model to reason about these things. I haven't actually heard it put that way before. So, and I guess your point is, people don't live in their tokens. And even if you look at the tokens, which purportedly have a utility element to them, for the most part, they're not actually buying the tokens to utilize network resources. There's probably 100 examples I could provide here. Mostly they're buying the tokens because they think the value is going to go up quite fundamentally. I mean, a good example, I think, would be something like Augur, not to pick on Augur, but, the Augur tokens were purportedly to participate in the prediction markets. It's got a healthy market cap, a couple $100 million, but the actual usage is extremely low. Clearly, most of the tokens are just being held as investments as opposed to, take advantage of the prediction market, which the token holders, for the most part, are not actually doing.
That's right. Yeah, and you can see it pretty objectively, right? Now, I will say that just because someone buys something because they hope it goes up doesn't mean that thing's a security, right? Like people hope BTC goes up in value, right? And they buy it for that reason. Doesn't make BTC a security. So the next sort of level of the analysis is say, what's the predominant reason, why people would expect this to go up? And if it's has to do with sort of ongoing entrepreneurial or managerial efforts of some person or group of affiliated persons, and they're sort of existentially integral to the value proposition of that, like we just saw with the sushi thing, right? Yeah, how can you tell that Chef Nomi was that people were depending on his entrepreneurial efforts? Because when he dumped the token and no longer had a strong incentive to continue exerting those entrepreneurial efforts, then the value of the token massively plummeted. So it's a pretty good indication, right? And I think, sadly, many blockchain related projects are probably more like the Chef Nomi sushi example than they are like the Bitcoin example.
Well, it's challenging if we're talking about claims on cash flows. The existence of cash flows kind of implies some sort of orchestrator that's actually doing work to cause those cash flows to exist. So it seems kind of paradoxical to believe that there's the possibility for like a spontaneous, I know this isn't very cypherpunk of me, but that a spontaneous kind of corporate, fully decentralized corporate entity could emerge that's actually producing something of value to token holders without explicitly, having an obvious kind of locus of control somewhere. Although maybe, we're sort of getting there. There's some pretty interesting experiments in terms of, having a claim on the cash flows generated by a smart contract, which nobody, strictly speaking, has direct control over. So maybe we're kind of approximating that reality, but it did always seem to me that most of these pseudo equity tokens were just ersatz ways of reapproximating the conventional corporate structure, as far as I could tell.
That's right. Yeah, and if it's essentially just a new way of having a startup, I don't think it should be any differently regulated from a startup, right? Now, you do raise an interesting point, right? Because I've spoken to regulators. I had a pretty good scenario, right, from a client where they really wanted to have like no ongoing efforts, basically, but the smart contract system was going to be set up in a way where, yeah, it was a little bit of what I call not a Ponzi scam, but a Ponzi game, right? Where people basically can get value by referring others. And so the flywheel gets going, but it's really just from unrelated people who want to come in and generate value for themselves. They might even be competing with each other to some extent to do that, and rather than from the creators or their investors and that sort of thing. So the response I got to that, and I think people should pay attention to this because it's easy to just take the word sufficient decentralization and think you mean by it the same thing that the SEC means, but I think they typically mean something pretty different, right? Because even in that context, where the analogy I used was, it's like a gumball machine sitting in a public square, right? And certain people can get the proceeds of the gumball machine, but no one's going to be out saying, hey, this is a great gumball machine. You should really use it.
Right.
Some of the SEC staff pointed to a line of cases that says pre-sale entrepreneurial efforts can satisfy the Howey test. Now those cases are very specific. They relate to like fractional interests in sets of life insurance contracts and so forth. But you'd be foolish to assume too much, I guess is my point, because the SEC is sharpening their pencils on this DeFi stuff, and some of these things are going to ultimately have to be litigated. For example, there's a circuit split, about that specific life insurance contract issue, and so you always just have to look at what is driving value to the token. And the best case scenario is that it's sort of lots of people, but no one in particular who's very special. And even in that scenario, there still could be arguments that it's a security, but there are somewhat weaker arguments.
So on the sufficient decentralization front, I think there was kind of a mini mania over this when Hinman gave that speech, and I kind of made fun of that a little bit by saying that issuers were adhering to an informal Hinman test, which they had kind of, I don't know, spontaneously ideated into existence, even though the SEC, was clear that there wasn't an actual Hinman test. What were your points of disagreement with that, and do you have kind of a proposed alternative there?
Well, I think the sufficient decentralization test is great. And I think it's very cypherpunk. I think it has the right idea, which is that if this really is different, it's like a public good, then there shouldn't be a regulatory penalty that impedes that public good from existing. The way it was rolled out is not ideal because they weren't very specific about it, right? So I tried to create what I think would be a reasonable safe harbor for saying you're sufficiently decentralized. And you kind of look at each element of possible power over a blockchain system. Validation power, right? Can anyone spin up a node and validate the full history of the chain? Or is the chain so heavy that that's virtually impossible, so you have to trust others to do that? Economic power, how heavily concentrated is ownership of the token with sort of the original team and the investors and that sort of thing? Consensus power, right? Who are the block producers or block validators? And are they in league with one another, or are they more competing with one another? And kind of like user power, right? Like how able are people who might not be core devs and might not be miners, and might not even be particularly large token holders, but are enthusiasts and use the technology? How much say do they have in what happens, right? And so you can look at all these things, and you could sort of, my argument would be each of them should be sufficiently decentralized, right? But I think instead what's happening now is people are just saying, oh, well, we let anyone mine on our network, so it's sufficiently decentralized. And I don't think that's what they mean, but they didn't make it clear clear what they mean. And so they sort of invited this, what I would call a catastrophe waiting to happen.
So you're saying that those multiple different ways to express power of the network, they're kind of individually necessary, but alone insufficient to constitute genuine quote unquote decentralization. You need many of them to hold for the network to be kind of considered decentralized.
That's right. You have to look at all the sources of power over a network, right? Because it's very easy to just play a shell game, right? You can say, you know what, we'll make we'll make mining very decentralized, but when it comes to upgrading the protocol, right, that's going to be put to a token vote, and basically the token whales decide that by virtue of their very large token holdings, right? Whereas in Bitcoin, for example, we saw this amazing thing where core developers sort of formed a coalition with what I would call users like social media personalities who are into Bitcoin and stuff like that. And they were able to push back against the change, increasing the block size that was mainly good for miners and certain types of businesses that wanted to use Bitcoin. And that was a close call who would win that. And that's kind of what you want, right? It wouldn't really be predictable in advance who would win any given power struggle. And there has to be kind of real politics. And it's pretty difficult to make any sort of serious change to the system.
That's very astute. And I agree that the outcome of 2x in particular was a strong vindication of Bitcoin's nicely poised governance distribution. But it wasn't clear that that was actually the case. Beforehand, we kind of had to go through it to learn that. And I think that's why I would say there's question marks over many of these other projects, because they actually haven't reached a scale yet where these political debates emerge. So in peacetime, everything looks great. They're nicely constructed governance systems can work fine and so on. But it's only in wartime and times of crisis when you discover who has power in the system. And
that's right.
Many of them haven't grown big enough where we've actually had the chance to learn that yet.
Yeah, exactly right.
So with that in mind, would you say that actually it's kind of incompatible to have the administrators or issuers of a protocol or network, to have them extract a rent from the system, extract value, and have that system be decentralized? Because if you look at the very successful examples of kind of unambiguous decentralization, Bitcoin, Monero, I would say, would be another example. The issuers haven't really monetized their efforts there. Obviously, Ethereum would be an exception to that rule. Is that kind of a rubric through which to judge these things? Or are you still optimistic that there's a way to square the circle and have issuers still monetize their activity within the network, but to have it evolve into something that's truly decentralized?
Yeah, my personal view, and again, there are splits in different circuits and so on, is that as long as the value of the token doesn't depend on things that the issuers are continuing to do, or doesn't predominantly depend on those efforts, then it doesn't necessarily matter that there's still upside in the project for the original creators, because it's not the fact that those people have upside that people are relying on and hoping to make a profit from their investment, right? So, where that would tend to happen, I would say, is where on a percentage basis, it's a relatively modest amount. Like right now, I think the Ethereum Foundation owns less than 1%. I don't think anyone knows how much Joe Lubin owns of ETH. So maybe it's quite a bit larger than that, and we don't know, right? But I do think that when the original team has a very large amount or a very large percentage of tokens, any reasonable person, and particularly when they also still have like a lot of funding from prior token sales or sales of like token warrants and things like that, and they're still like kind of together as a company and funded out of those amounts, it's hard to think that a reasonable person wouldn't look at that situation and say, hey, there's a group of people here who have both the talent in terms of knowing the protocol, the willingness in terms of already having shown that they like to work on the protocol, and the incentive in terms of having lots of tokens, and the funding in terms of having lots of funding, that they're going to be a continued source of driving upside to this token, whether it's entering into commercial deals to get more people to use the system, doing fancy things to try to grow the market like MakerDAO is doing by adding more collateral types like USDC, and who knows if there was some commercial deal there or not. Who knows if there's a commercial deal in any of these new types of collateral they're adding. It's hard for me in those sorts of situations, to say that the people who are buying aren't still depending on the efforts of that team for the profits that they hope to realize.
So with that in mind, I mean, and you've been somewhat critical of the SEC's trajectory so far. What would be your ideal scenario here? What would you like to see, both in terms of how the SEC engages with the industry and then the kind of disclosure standards that emerge for some of these token projects?
Ideally, I think there would be a modified version of Regulation A+, which allows people to sell up to like 50 million worth of a security and have that security be freely trading. And then, basically the block stack model, but a better version of the block stack model, one that's not quite as heavy on the token issuer and doesn't take as long and isn't as expensive. And then that combined with a real test for when you become sufficiently decentralized. And it could be a very conservative test because, it doesn't have to be exclusive, right? You could still argue based on just securities law principles that you're no longer a security. But usually if it's a safe harbor of some sort, it's conservative. But combining those two things together with some rule changes that say, hey, it's okay for something to trade on Uniswap because, that's not really what we think of as an exchange. It's more this algorithmic thing, and it's not, custodial, and it's not prone to the same abuses and so on. That would be the ideal, right? So basically, like tokens can be securities for a period of time. They can do that in the native environment where they're supposed to operate, and they can do that in a way that actually leads to some liquidity during the period they're a security. In general, I would just we've just been talking about securities laws. There's also tons of commodities laws issues, right, which we haven't even hit yet. But in general, I just think the regulators should be way more proactive, and they shouldn't be as chicken as they are to say that something might actually be okay with them, right? They're just very reluctant to sort of say anything is okay. And I think that's bad because then all you have is the stick. And what's happened is I just have no way of counseling my clients, right? Everyone who has gone the regulatory path bitterly regrets it. Founders talk to each other. And now founders are unwilling to talk to regulators because there's just no particular reason to think that they'll have a good outcome, right? So they need to develop some carrots, and they've just done a really, really poor job at doing that.
Not to weigh into politics, but what would you expect in terms of the election outcome? Do you believe that would much change the securities authorities' engagement with the industry, depending on which way it goes?
Well, it could. One possibility that would be very bullish for crypto is Trump gets reelected and Hester Pierce becomes chairwoman of the SEC. Right. And we know her views, right? I mean, obviously she's still limited to what the law is, but there's a lot of room for interpretation there. And, she will be dealing with a staff that I think a lot of them disagree with her views, but nevertheless, she'd be the head honcho, and she clearly is reform minded and thinks the securities laws should be easier to comply with, right? So that'd be very bullish for crypto if that happens. Don't know, have no way of predicting, right? If a Democratic Democratic president gets elected, and by the way, if Trump gets reelected and it's not Pierce, then I would say it's anyone's guess, right? Clayton was a Trump appointee, and Clayton was very, very tough on tokens, and Trump has said a lot of derogatory things about cryptocurrencies, right? Who knows? If a Democratic president gets elected, what I would invite people to do is look at Elizabeth Warren in her questioning of Pierce when she had to be confirmed as a commissioner. And it was very, very tough questioning, right? It's now happened twice. The Democrats are just less free market oriented in general, or maybe a more charitable way of putting it would be that they view free markets as requiring a lot of regulation in order to truly be free. And so Democrats haven't really said a lot as a position matter on cryptocurrencies, I think, other than that one guy who has a donor as a payment processor as a donor. I'm forgetting his name. He's very vocally anti-crypto, but in general, you can assume that they're more regulation oriented, and so while they might not be focused on crypto, because I think they're more focused on holding CEOs and things like that accountable for any given thing that comes across their desk, they're going to look at it more from the standpoint of interpreting the securities laws more literally, I think, and more broadly.
To the extent that Biden is currently the favorite, I mean, do you think the token markets are actually underestimating the risk from a Democratic administration? That's probably my view, I would say.
It could be, but I don't know, right? I think that the Clayton thing is interesting because he was looking to plant his flag and looking for a mission, and I think focusing on crypto really let him come out strong against something and gave his tenure definition. But now there's someone who's already done that, right? And there's a lot of things already happening at the SEC. So I don't know that a new commissioner is, regardless of what their biases are, I don't know that they're particularly incentivized to go on a crusade against crypto, because there are bigger fish to fry. Right. I personally, I'm not I still hold a lot of crypto. I'm not anticipating some big market-wide plunge. I do think no matter who gets elected, there will be a couple big actions against DeFi, because there just have to be. And that could, that's probably going to affect the prices somewhat. Right.
So I've had you on for over an hour now, and this has been one of my favorite. We've had actually quite a few lawyers on the podcast. Those are always my favorite episodes, maybe because of my strange infatuation with crypto law, which maybe perhaps doesn't make that much sense given what I actually do for a living. But I guess where we'll leave it is, what is your current level of optimism over the possibility for entrepreneurs to create concepts which do involve sovereignty over assets and money, and can exist in concert with the legal regime? I mean, are you optimistic around that? Does something need to change? Do the regulators need to change their view? What are the prospects for, the kind of crypto law industry?
Well, certainly producing software in the United States is, it's one of the best places to produce software because we have strong First Amendment protections, right? The deploying the software and trying to make money off of it, that's where it gets a lot harder. And I'm not too optimistic on the combination of deployment and the people who deployed wanting to get paid for their work, being compliant with law, because by its nature, this is something that enables exit from the legal system and enables you to, custody and do transactions with your stuff, even if an intermediary or a government ordinarily wouldn't permit you to do that. That is both good and bad, right? It's bad because it means this is never going to be run like Silicon Valley exactly, where there's just like this enormous like American prosperity that's like totally legitimately generated from it. It's good in the sense that the people who are working on this for the right reasons, that is to really build public commons that are usable by anyone and don't have to trust a lot of people, they remain revolutionaries, right? And I think they can carry that badge proudly, but you can't expect to have your cake and eat it too, right? You can't expect to, Che Guevara got on the T-shirt long after he was dead and buried, right? And that is a reality.
Yeah, you can't sell merch when you're still conducting the revolution. Which of the many threads in the industry excite you the most, and which do you think will be the most enduring?
Well, I would say, first of all, I still remain excited about Bitcoin because I just think it survived the most battles, as you said, and it has the most clearly defined culture, and it just creates this enormous firewall against any kind of bullshit or capture. And so, to me, Bitcoin is still, like, in terms of the attitude around it, still the most kind of punk rock and pure cypherpunk proposition. Now, that also means it can be very slow to change, and that the changes that do happen on other layers, right? So Ethereum, is amazing because it's just much easier to hack on, right? And people just do crazy stuff. And the DeFi innovation that's happening there is nuts. I'm very excited about these sort of like new fair launch projects in air quotes, that try to give governance to everybody right away. I wouldn't say any of them are fully true to their statements yet, but it is an interesting idea, and it does sort of de-risk the main regulatory risk, which is that like VCs fund these things and it's just so clear, VCs want to make a profit, right? So I love this like community efflorescence in the DeFi world. Yes, it's a little bit hairy, but I think there could be interesting movements that come out of that.
Well, Gabriel, it's been a pleasure. Thanks so much for coming on and sharing your thoughts with us.
Thank you. My pleasure, sir.